Good morning. On behalf of the Law School and the University of Montana, we welcome you to this space. My name is Jordan Gross. I teach criminal law classes at the Law School, and it's my privilege to welcome you to the Supreme Court's hearing in the case of City of Kalispell versus Thomas Salsgiver. The university is home to Montana's only law school. We train lawyers from Montana and the region, and we also serve the state's lawyers and the bench and the judges and the public through training and educational opportunities such as this. An informed citizen is an empowered citizen, and I commend you for making the time to come watch your government in action. The Supreme Court usually does its work in Helena, and I commend the court for bringing its business to the people around the state through events like this. So my job today is to help you understand today's proceedings. You do need to know that justices do not come to this hearing cold. They've read the parties' written submissions, they've done their own research, and they've discussed the case at length with one another. So to people who are not involved in the case, the court hearing can be a little hard to follow. There's a lot of shorthand and a lot of legal jargon, and my goal today is to give you a guide for what you're about to hear so you can better understand the conversation between the justices and the lawyers. And the collective goal of everyone involved, the law school, the lawyers, the judges, the justices, and everybody here, is for you to leave today feeling like a better informed citizen. So we're going to start first with the big picture and the structure of the court system, and then we'll talk a little bit about process, and then we'll get into details of the case being heard today so you understand what's going on. First, I want to talk a little bit about American courts and how they do their work. Our federal system, of course, consists of three separate sovereigns: the federal government, the tribal governments, and the 50 state governments. And indeed, this building sits on the Aboriginal territories of the Salish land and the Kalispell people, and we express our appreciation for that fact. The three U.S. sovereigns, the federal, state, and tribal governments, have court systems that are completely independent of one another, but they're very similar in many respects. And one of the similarities is that the courts have different court systems and different layers that have different functions. So the first layer is what we call the trial courts. These are our first decision makers. Trial courts take evidence, they hear from witnesses, and they decide facts. Issues of fact in a trial court can be decided by a judge, or they can be decided by a jury. But deciding questions of law is always the judge's job. And the main issue today revolves around when a defendant is entitled to have a jury hear his or her case, and when can a state require a defendant to try his case in front of a judge rather than a jury. So the next level in our system, next come the appellate courts, or what we call the reviewing courts. Once a trial court produces an opinion, it might be a jury verdict or it might be a legal ruling by a trial judge, the party that lost can ask another court to look at that decision and overturn it if it is incorrect. A party is generally entitled to at least one opportunity for review from a higher court. So two really important points about this review. In a criminal case, the government cannot seek review of an acquittal on the facts. In our system, once a fact finder acquits a defendant, that's final. There is no more review. And the second piece that's important is that our system treats questions of law differently from questions of fact. A reviewing court may not make new factual findings. It only gets to consider questions of law. And so that's why today you won't see any witnesses. You won't see the lawyers trying to introduce any kind of evidence. And all you will hear, you won't hear any arguments about the facts, you will hear arguments about the legal significance of the facts. So let's talk a little bit about the federal, tribal, and state court systems. Which cases go where? The federal courts can hear questions arising under the federal Constitution, the federal laws, and the treaties of the United States. And the organization mirrors just what we were talking about. We have federal trial courts. These are called the federal district courts. And each state has at least one federal district. Some have more depending on population. For example, Montana, We are a low population state. We have 1 district. California has 4 federal districts. We also have what we call federal specialty courts, for example, the bankruptcy courts. And we have the federal reviewing courts, the courts of appeal. And those are called the federal courts of appeal. And they hear appeals or complaints from the federal district courts, the federal trial courts. And those are arranged by circuit. And each circuit encompasses multiple states. Montana is in the 9th Circuit Court of Appeals in the federal system, and this is the largest circuit in the United States. And then we have, of course, the U.S. Supreme Court. That is the highest court in the land. And the U.S. Supreme Court hears cases from the circuit courts or that come out of the state Supreme Courts. And with some narrow exceptions, the United States Supreme Court only hears cases that it chooses to hear. That way, the way a party seeks the Supreme Court review is by what we call a writ of certiorari. And you may have heard the term a writ of cert, and that's what they're talking about. That's somebody asking the U.S. Supreme Court to accept their case and review it. Our tribal courts can hear questions arising under tribal constitutions, charters, tribal laws and customs. Many tribes have tribal courts. Indeed, 7 of the 8 tribal nations located within the boundaries of Montana have tribal courts. Tribes without their own court system use courts of Indian offenses that are known as CFR courts, and those are administered by a federal agency. All tribal court systems have parallel trial courts and courts of review. And that brings us to our state courts. Questions are brought to the state court that arise under the state laws and constitutions, but importantly, a state court can also consider questions of federal constitutional law that arise in the context of a state prosecution. So one really interesting and very complicated aspect of today's case is that it requires our court to consider the relationship between a provision in our state constitution and the requirements of federal constitutional law, and decide whether this requirement under federal law overrides our state constitutional provision. In Montana, we have 2 types of trial courts. We have courts of limited jurisdiction, and we have courts of general jurisdiction. Our courts of limited jurisdiction include our justice courts, our municipal courts. There are differences among those, but typically those courts are only allowed to hear misdemeanor cases and small claims. And in Montana, these are our busiest courts by far. This is where most Montanans will encounter the justice system. And then we have our courts of general jurisdiction. Our trial courts of general jurisdiction in Montana are called district courts, also referred to as county courts. And these courts can hear all cases at the trial level that arise under state law. And of course, if they raise issues of federal law, they can consider those issues as well. Now, our district courts are typically trial courts, but sometimes they act like appellate courts. They act like review courts. And they do have authority to hear appeals from our courts of limited jurisdictions, our justice courts and our municipal courts. And that's exactly what happened in this case. We had a decision that came out of the Kalispell Municipal Court in a misdemeanor case, and it was appealed to the Flathead County District Court. And the decisions from our county courts can be appealed to our Montana Supreme Court, which is how this case got here, and that's what we're doing here today. So I want to talk to you a little bit about the federal system and local and state criminal prosecution. So of course, today's case comes out of a criminal case, and crime and community safety are typically matters of uniquely local concern. And most criminal cases in the United States, by a long shot, are prosecuted at the state and local level, not by the federal government and not by the tribal governments. Under our federal system, states, tribes, and local governments have wide authority in defining what constitutes criminal conduct. They get to decide what wrongdoing will subject you to the criminal sanctions, and they get to decide how it is punished. States and tribes, however, have far less authority in determining how criminal cases are prosecuted, what the rules of the road are in criminal cases, the procedural requirements that are due a defendant in a criminal case. This is because the rules in how a defendant is prosecuted are subject to limits under federal law. We call these limits the floor because they represent a bare level, a minimal level of protection that federal law says state, local, or tribal courts must give to a defendant when they prosecute that defendant in their courts. And state and local tribal governments may extend more protection to defendants in their courts than is required by federal law. So they may raise the ceiling, and many jurisdictions do, including Montana, may give more protection to their defendants, but they cannot go below the federal floor. An important piece of this case is a possible conflict between a Montana constitutional rule of criminal procedure and a federal rule of criminal procedure, and a conflict between what the state law and the state constitution says a state trial court may do in a state criminal prosecution in Montana, and what federal law says states must do in a criminal prosecution. In our federal system, although the states have wide latitude to enact and enforce laws, they must always defer to federal law on questions of the federal Constitution. And this is because the U.S. Constitution says that federal law is the supreme law of the land. In criminal cases, this federal law gives defendants a number of procedural rights that apply no matter what court system they are in. That is, federal law sets out some basic rules that must be observed by state, tribal, and local courts when they prosecute somebody for violating a law under their own constitution and their own laws. So no doubt you've heard of some of these trial rights. They include the right against self-incrimination, the right to confront witnesses, the right to assistance of counsel. And today's case involves one of those trial rights, the right to trial by jury. And these basic trial rights, they come from different sources depending on whether trial is held in federal, state, or tribal court. In federal court prosecution, a criminal defendant's trial rights come directly from the Bill of Rights under the U.S. Constitution, the Fifth and Sixth Amendments specifically. In state cases, a defendant's constitutional trial rights do not come directly from the Bill of Rights. Rather, they come from the 14th Amendment. And the 14th Amendment says that states cannot deprive people of their due process rights. So the U.S. Supreme Court has interpreted the 14th Amendment due process guarantee to require states to provide criminal defendants most, but not all, of the trial rights that are set out in the Fifth and Sixth Amendments to the U.S. Constitution. Neither the Bill of Rights nor the 14th Amendment apply in tribal court, and that is because the Indian nations were not signatories to the U.S. Constitution, so the restrictions on state and federal governments that are in the U.S. Constitution do not apply to the tribes. But many similar protections are required in tribal court under a federal statute that's called the Indian Civil Rights Act of 1968. So all this matters because this case involves this fundamental question of the extent to which federal law constrains state court criminal procedure rules in our federal system. I want to talk to you a little bit about the structure of criminal law and specifically the right to trial by jury, which is at issue today. And I want to give you some terms and some concepts to help you better follow today's discussion. So the first concept is the categorization of crimes based on their level of seriousness. Crimes are generally categorized first as either a misdemeanor or a felony based on the length of the potential sentence they carry. And that's the state or the tribe gets to designate the sentence. And then misdemeanors are further categorized as either petty or non-petty. Non-petty might also hear the justices and the lawyers refer to them as serious misdemeanors. So that leaves us with three categories of crimes in the American system. Crimes that are punishable by up to 6 months are called petty misdemeanors. Crimes that are punishable by up to 1 year imprisonment are called serious or non-petty misdemeanors, and crimes that are punishable by over 1 year are called felonies. The second concept I want to introduce you to is the right to trial by jury. So as we already discussed, facts can be found by a judge or they can be found by a jury. And a case tried without a jury is called a bench trial. In that case, the judge decides the facts and applies the law. And the right to a trial by jury was included in the U.S. Constitution Bill of Rights because it was deemed important by the founders to give defendants, criminal defendants, the opportunity to have their conduct evaluated by peers and to interject the jury, to interpose the jury as a check between the governed and the governors. The Sixth Amendment, if you just look at the text, says in all criminal prosecutions, the accused shall have the right to trial by an impartial jury. But based on common law and history, the U.S. Supreme Court has interpreted the Sixth Amendment to provide that you are entitled to a right to a trial by jury in some cases, but not all cases. And that's where this concept of the level of seriousness of the offense comes into play. The U.S. Supreme Court has said the Sixth Amendment only guarantees a federal right to trial by jury in cases involving serious misdemeanors and felonies, meaning it excludes the non-petty misdemeanors from the right to trial by jury. You still get a trial, but it is by a judge. So why would a state want to forego a jury trial or ask a defendant to forego a jury trial? They're expensive and they're time-consuming. And so in some instances, a state might seek to create procedures to dispense with the right to a jury trial in some cases. And Montana law contains just such a provision, and that is what is at issue in this case. The third concept you'll need to understand to follow today's argument are the doctrines of waiver and forfeiture. The trial rights that a defendant has are personal to the defendant. That means they can be given up by the defendant, and the law recognizes two primary instances in which a defendant will be found to have given up a constitutional trial right. The first is by waiver, and the second is by forfeiture. A waiver occurs when a defendant voluntarily gives up a known right. And the U.S. Supreme Court has held that as a matter of federal constitutional law, a defendant will not be found to have waived a federal constitutional right by default. Rather, the federal constitutional demands a showing that the waiver of the constitutional trial right was knowing, intelligent, and voluntary. Knowing means the defendant was aware of the nature of the right he was foregoing. Intelligent means the defendant understood the nature of what he was doing. And voluntary means that the defendant was not coerced into giving up the trial right. So an example you might be familiar with is the guilty plea. A guilty plea, of course, requires a defendant to give up a number of trial rights. Those include the right to a trial, the right to a jury trial, the right to confront witnesses, the right against self-incrimination. And for a plea to be binding under federal constitutional law, the trial court must ensure that the defendant's waiver of all these rights is knowing, intelligent, and voluntary. And it does that by engaging in a conversation with the defendant, by explaining each right to the defendant, and asking the defendant if he or she understands what she or he is giving up. The other way a defendant may be found to have given up a constitutional trial right is by forfeiture. And under the forfeiture doctrine, we say that a defendant has forfeited the protection of a constitutional right by engaging in certain conduct. By way of example, the federal Constitution guarantees a criminal defendant the right to confront witnesses at trial. And that means that a state cannot present the testimony of a witness in any other form at trial other than by in-person testimony. And so if a witness does not show up at trial, the state may not introduce an alternative to that in-person testimony. It may not, for example, introduce a statement that the witness gave to law enforcement prior to trial. However, if the defendant engaged in conduct that procured the absence of the witness, for example, if the defendant intimidated the witness or killed the witness, we will allow the state to introduce alternative evidence of the witness's testimony and the witness's out-of-court statements. Because in that instance, we say the defendant has forfeited his right to confront witnesses by engaging in wrongdoing, engaging in certain conduct. So that's what federal law has to say about giving up federal constitutional rights. Montana's Constitution also has something specific to say about giving up the right to trial by jury. Our state constitution provides that the right to trial by jury is secured to all, but it also says that the right to trial by jury may be given up by a default of appearance. That means a failure to show up at a court hearing or by consent of the parties. So with that background, let me give you the particulars of this case. Mr. Salsgiver was charged with partner family member assault, and the parties agree that this is a non-petty misdemeanor offense. That means all things being equal, he was entitled to a jury trial under the federal Constitution. Mr. Salsgiver subsequently entered a not guilty plea. He was released, and he was informed by the municipal court in writing that he was required to personally appear for all court proceedings. Mr. Salsgiver was also assigned an attorney to represent him, and he was advised that under Montana law, a failure to appear at future court hearings would result in a waiver of his right to trial by jury. The same court later issued a notice scheduling a pretrial hearing called an omnibus hearing. That notice also stated that the defendant's personal presence was required and that a failure to appear at that hearing would result in a waiver of his right to trial by jury. Mr. Salsgiver did not appear at the omnibus hearing, but his attorney did, and the court concluded, following that hearing, that under Montana law, Mr. Salsgiver had waived his right to a jury trial by not showing up, and it set the case for a bench trial, that is, a trial without a jury. Before trial, Mr. Salsgiver asked for a jury trial. He argued that he never voluntarily, knowingly, or intelligently waived his right to a jury trial under the federal Constitution. The municipal court denied his request and proceeded with a bench trial at which he was found guilty. Mr. Salsgiver appealed this ruling to the Flathead County Court. That court agreed with the municipal court and upheld its decision. He has now brought this issue to this court, and he asked this court to reverse those lower court rulings. So what is in dispute is whether Montana's constitutional provision that says a defendant gives up the right to trial by jury by failing to appear in person at a court hearing is sufficient to satisfy the federal constitutional waiver standard. In other words, can Mr. Salsgiver be deemed to have knowingly, intelligently, and voluntarily given up his federal right to have his case decided by a jury for failing to show up at a court hearing, or does the federal Constitution require more? So what happens after today's hearing? After hearing argument, the justices will meet in conference to discuss the case. They will vote on which side the law supports, and they will issue a written decision directing the trial court what it should do. If Mr. Salsgiver wins, the case gets reversed, and he is returned to the trial court for a jury trial. If the state wins, Mr. Salsgiver does not get a new trial. And since this is a matter of federal constitutional law, either side can seek further review by the U.S. Supreme Court if they are not happy with this court's decision. This is a deliberate, careful, thoughtful process, so it may be weeks or even months before an opinion issues from this court. And just a last word about protocol. This is an official court proceeding, so while we are here, this space is a court of law, and so we would ask you to please remain silent and seated while the court is in session. Please turn off your mobile phones and any other devices that may disrupt the proceedings. And I thank you again for being here. I am confident that you will find this to be time that is well spent. Thank you.
All rise and give your attention. The Honorable Justices of the Montana Supreme Court. This court is now in session.
Good morning. As you're aware by now, this is the time and place for an oral argument in DA number 160445, City of Kalispell versus Thomas Salsgiver. For those of you who aren't familiar with members of the court, let me take a moment and introduce the members of the court. On my far left would be Justice Jim Rice, and Justice Jim Shea, Justice Lori McKinnon. I'm Mike McGrath. I'm the Chief Justice. On the other end, it's Justice Dirk Sandifer, Justice Beth Baker, Justice Ingrid Gustafson. We're pleased that you're here. We're pleased to be here at the university. We want to thank the University of Montana, the University of Montana Law School, and Dean Kurgis for hosting this event. And with that, we'll begin. Are counsel ready to proceed? Mr. Peabody.
Mr. Chief Justice, and may it please the Court, in this case, the default of appearance provision in Article 2, Section 26 of the Montana Constitution was applied to deny Mr. Salsgiver his Sixth Amendment right to trial by jury. Under Article 2, Section 26, there are two distinct circumstances in which trial by jury may be waived under state law, as this Court stated in Missoula v. Cox. First one being default of appearance, and the second is where parties consent in a manner expressed by law. The text of the Sixth Amendment does not have a default of appearance provision in it. The state, in their arguments, are insisting that Mr. Salsgiver indeed can waive his right to trial by jury under the Sixth Amendment upon a default of appearance, even though the Sixth Amendment contains no such provision. Now, Mr. Salsgiver, he is charged with a serious offense in this case, as it was over 6 months. That's where the U.S. Supreme Court has drawn the line between petty and serious. It's the same for a misdemeanor, that's 1 year, or a deliberate homicide. So, if the court were to accept the state's argument in this case, an individual could serve a life sentence who missed an omnibus hearing, who was never convicted by a jury of his peers.
Mr. Peabody, I interpret the state's argument to be a little bit more nuanced, and not just that it was a waiver by default of appearance, but an actual waiver by implied consent or express consent, because he did sign the conditions of release and agreed to them, among which was that any failure to appear would waive his right to jury trial. And so he knew when he failed to appear that it would be deemed a waiver, which seems to me to be a bit different from a default of appearance argument.
Yes, they made a few different arguments. In the original brief, they did not argue Section 26. They argued waiver by conduct pursuant to the Third Circuit's Goldberg case. And they're asking the court to extend this waiver by conduct from the context of these loss of counsel cases to loss of right to jury trial. So they made a couple of different arguments as far as waiver by conduct, which also known as forfeiture by knowledge. The Goldberg case said that it's more appropriately forfeiture by knowledge because the person does not actually, waiver is an intentional relinquishment or abandonment of a constitutional right, whereas Goldberg acknowledged that in these cases, the defendant was warned, do not continue on with your misconduct, and if you do continue on, you will lose that right, and the defendants continued on knowing what the consequences were. The Goldberg case acknowledged that that is even the case where the defendant expressly says, I don't want to proceed pro se, I want an attorney, but whatever the circumstances in that particular case, they didn't like their attorney or they were just being plain difficult, it was preventing the trial from going forward. That is...
Well, doesn't failure to appear prevent a trial from going forward? I mean, I guess in this case there's trial in absentia, but typically a failure to appear would prevent a trial from going forward just by, like, being difficult and not working with your counsel.
Well, I mean, that implicates a right to be present. And so, as this court has ruled, as other courts have, that, you know, as the U.S. Supreme Court ruled in Taylor, if somebody knows that their trial is going to happen, and if they voluntarily absent themselves, then a trial can go forward. And Mr. Salsgiver would have no reason to complain if there was a jury trial occurred in this case, and if he did not show up to this jury trial. As we know, he did show up in this case, but if he had not shown up, I couldn't stand here today and say you should reverse this case because he didn't have a jury trial. So, practically speaking, though, it's true that if this court were to rule as I'm asking the court to, the courts are not going to be setting jury trials on a weekly basis, you know, 10, 15 a day. In Kalispell court, there'd probably be 10 or 15 bench trials every Thursday. That's not going to happen.
Oh, sorry. Finish your sentence here.
But no, it does not prevent, the right to a jury trial does not prevent, or a defendant not appearing does not prevent the trial from going forward.
So, counsel, do I understand from your argument then that you are conceding that under the Sixth Amendment there are situations in which a defendant can give up his right to jury trial by virtue of his conduct? Is that what I...
No.
No?
No. I'm sorry, I don't...
I thought you said that if the defendant had not shown up at his trial in the district court, you would not be here asking for a reversal. That's what I understood.
No, I'm sorry.
As long as the trial was conducted by a jury.
Correct. If he had not showed up to court and there was a jury and a jury found him guilty, I couldn't come to court here today and say he was denied his right to a jury trial.
So let me ask you this question then. Do you believe under the Sixth Amendment there is any way in which a defendant can give up their right to a trial by jury by virtue of his conduct?
It has to be knowing, intelligent, and voluntary waiver. And so the waiver by conduct cases, as they're termed in Goldberg, the forfeiture with knowledge cases, not if there's not a knowing, intelligent, and voluntary waiver.
So could there be, if rather than just the court by virtue of the warnings that were in the notices, if this on remand, if the court were to conduct a hearing, could the, I guess in this case it would be the municipal court, conduct essentially a fact-finding hearing to make a determination whether by virtue of the conduct it was knowing, voluntary, and knowing, intelligent, and voluntary?
So do you mean in this case if it were to be remanded to the court?
Yes, I mean in this case the court just made a determination that, because we've had the cases, I think it was in Girard, where we've talked about, you know, it's not even under Article 2, Section 26, where it's not automatic. You have to look at the circumstances. In this case, if the court had said that, okay, we need to conduct a hearing to determine whether the waiver was knowing, voluntary, and intelligent by virtue of his conduct, but not make it just automatic, you didn't show, there was a warning, therefore you've waived your right to a jury trial. Could it still be a determination that his waiver by conduct was knowing, voluntary, and intelligent?
As far as the waiver by conduct, the entire doctrine of it, it is within the forfeiture umbrella. And as Justice Scalia stated in Freytag, you cannot forfeit your right to a jury trial.
So what you're saying is that it would have to be, maybe we add another thing, it has to be express. You have to say, I don't want a jury. You just can't do it by conduct. I'm just trying to make sure that that's
correct.
What the landscape is here.
Yes, I mean, waiver by conduct in the sense that it's a form of forfeiture, as Goldberg states. So, I mean, we talk about, waiver by conduct with regard to the Fourth Amendment. It's different than like State versus Rhyme, where the defendant told his attorney, I want to waive my jury trial, and then they show up the morning of the trial, and the attorney says, I still want to waive, he still wants to waive his right to a jury trial. He doesn't say anything. They don't get an affirmative on-the-record waiver from the defendant. He doesn't complain. There's an entire jury trial that goes forward. If that sort of conduct, yes, it could be. That's entirely different than the waiver by conduct in Goldberg. Misconduct is not, you cannot punish somebody by denying them their right to a jury trial. And Gilchrist versus O'Keefe says that as well.
So do you think, though, I mean, do you have any concerns because it's all tied to a release order as well? That, I mean, whether that's really a voluntary and knowing waiver when somebody says, I'm going to keep you in jail if you don't sign this. Outside of that, like, have they not conditioned release on it and told them, not conditioning your release on it, but if you have to show up personally. If you don't, I'll consider it a waiver. I mean, and if he doesn't show up, is that conduct enough? I'm just trying to figure out where the conduct comes in.
Well, I think it has to be the defendant's choice. It is they have to be the one, it can't be put upon them. It needs to be a voluntary, knowing, and intelligent waiver. As far as the cases interpreting, as Johnson versus Earps says, and all the cases following that regarding waiver, it needs to be an intentional relinquishment of a constitutional right. That has to be the defendant's goal, is they have to want a bench trial versus a jury trial.
As occurs in felony prosecutions.
Correct. And as far as these cases are concerned, there's actually very few misdemeanor prosecutions that go to bench trial involving, it's a very select number that are actually serious misdemeanors. The cases under Cox and Trier and Sherlock and Gerard, those line of cases would continue on if the court were to adopt or if the court were to agree with Mr. Salsgiver in this case, because all of those defendants do not have a Sixth Amendment right to a jury trial. And so this really only affects the main ones. It would be a second, third-time DUIs and partner family member assaults. And then there's a few other ones that are the less frequent, you see, animal cruelty or...
So, counsel, that brings me to a question. If you have conceded that the criminal endangerment waiver was valid and that conviction should stand, right?
Criminal mischief, yes.
Okay. So on remand, should we decide that there was not an effective waiver on the partner family member assault, how does that trial going forward look? In other words, the two are tied together.
Right. Well, I think I'm blanking on the name, but the evidence rule that when it's so intertwined with the offense, you can't keep that evidence out. So the evidence regarding the criminal mischief would have to come in, I would think.
And let me also ask you about 4616-120, which allows a defense attorney to appear in the absence of the defendant, and that is not a default by appearance.
So let's put that, if we could, in the context of going back to the facts of this case, Article 2, Section 26, where it talks about upon default of appearance. In this case, what we're talking about is the omnibus hearing. And it seems to me an argument could be made that the attorney showed up, so there was not a default by appearance in this particular case. Because don't we allow trials even when the attorney's there and the defendant isn't? So why would this be a default by appearance if the lawyer made an appearance?
Well, I believe the rationale is that he was ordered to be present at that hearing. So if the court wanted to make that ruling that he couldn't be a default because the attorney can, I wouldn't oppose that, but...
Well, there might be some that at least are interested in pursuing that discussion.
Well, does it apply to the other misdemeanor?
Not on my reading, but to be completely frank, I haven't spent too much time analyzing that. But it appeared that when they are ordered to appear and fail to appear, because that was the Cox decision as well. If they're allowed to appear by counsel at the trial, then I'm not sure how those cases were decided the way they were. It seems like it would take care of all of the cases.
Well, I want to kind of go back to Justice McKinnon's question, though, about and you were looking at it from an evidentiary standpoint, the criminal mischief with the PFMA, and that they're so intertwined. And I'm just thinking of this from a precedential standpoint and moving forward. I mean, if they're so intertwined, I mean, let's assume for the sake of argument that we say under the Sixth Amendment that you can't waive by conduct. And you have two misdemeanors, one that is a serious offense under Baldwin, it's over 6 months, you have the situation that you have here. Would it be, just trying to picture how this would look then, is that you would then bifurcate these trials and you would say, okay, moving forward, the serious offense would be, there's a bench warrant issued or whatever have you, and then under the misdemeanor that's under 6 months, that you would just have that would be a bench trial, or they're tried together, but the judge renders the verdict I'm just trying to see how unwieldy it comes, or does it become, because they're not severed or they're not bifurcated, that you basically have a right to a jury trial in a non-serious offense as long as it's being attached to a serious offense?
Yeah, that's a good question. As far as a trial judge, it would constitute, I mean, there's two answers to it. From a practical standpoint, I think it would make the most sense for a trial judge to try them together, rather than do two trials. Now, if a judge wanted to do two separate or to sit as the finder of facts for the less serious, or for the petty offense, I'm guessing they possibly could.
But then aren't you running the risk of inconsistent verdict? I mean, particularly if there is this inextricable intertwining of the evidence with the two offenses. You find somebody guilty of, the judge finds somebody guilty of the lesser offense, and then the jury finds them not guilty, or vice versa. I mean, it just seems kind of in for a penny, in for a pound. It wouldn't seem
right. It wouldn't make sense to me why they would do that. I haven't researched that question, so I can't give you a solid, 100% answer, but it wouldn't make a whole lot of sense for the judge to, if you're going to have a jury trial, you might as well have the jury decide all of the cases. As far as,
So are you really advocating that we send the whole thing back because it's not severed and it's tied inextricably to the felony?
Well, in this case...
It seems like that isn't what you argued originally, but in talking through it, it seems like maybe that's where you are now?
No. It makes sense to sever it in this case only because the trial has already happened. But as far as going forward, it doesn't make a whole lot of sense to do two separate trials for two different offenses. The Nebraska and Kansas cases that I cited, or maybe it was just the Nebraska case, Bishop, but the defendant in that case was charged with resisting arrest, which was a serious offense, and then two petty offenses. And they had the rule in Nebraska where you have to file an affirmative waiver for a misdemeanor offense to get your right to a jury trial, and the Nebraska Supreme Court stated that that's fine when you don't have a Sixth Amendment right to a jury trial, when it's only your statutory right. But when you have a Sixth Amendment right, it needs to be a knowing, intelligent, voluntary waiver, and failure to file your notice demanding your jury trial demand is not a knowing, intelligent, voluntary waiver, even though you were told you were required to file this waiver. Similar to this case where you were told you were required to appear in court, and if you don't, then you waive your right to a jury trial. It's an omission of an act that you're required to do. One, not coming to court, and the second, not filing the jury demand. And so in that case, they affirmed the petty offense convictions, and they remanded on the serious offense convictions. And so I was asking for the same relief on this case based on those cases. But no, I do not think it makes sense at all to try petty offense and a serious offense two separate ways in two separate trials. I think it would make sense. If you're going to have a jury trial, the jury should decide all of the counts.
Well, and that's the way functionally it works anyway in district courts, is the offense, if it's a felony DUI, it's automatically in district court, and I think I don't know what statute, but it allows for the misdemeanor offenses to be charged along with that felony.
Yes.
Counsel, can you go back to the Chief's question, Section 26 of the Constitution, which reads, "but upon default of appearance," and in the context of the statute, which allows, I mean, how do you reconcile, or what would you say to reconcile 4616-120, which allows counsel to appear and the defendant not have to appear? How is that, when we've allowed for that in that statute, how is that a default of appearance under the Constitution? Maybe I didn't ask that question.
No, you did. I don't have the statute in front of me. I thought that it was, you're allowed to appear by counsel unless ordered to appear by the judge.
That's basically what it says.
So if it states that, then if the judge orders you to appear, you must appear. So, again, I think if that were not the case, and if you did not have to appear, or if you could appear by counsel, then the defendants in Cox and Trier and Girard, Sherlock, I don't see how they could have waived their right to a jury trial if they were permitted to appear by counsel. So,
So essentially, you're arguing if we go that route, it would be your opinion that we have to overrule our prior cases.
Yes, which is why I didn't argue that in my briefs. So.
Do you think that the statute is contradictory to our Constitution's right to jury trial, where you say, although language, although the court can order your appearance, but it also says that the attorney can appear for you. And so, do you think requiring personal appearance is contradictory to some extent to our constitutional guarantee of a jury trial?
Do I think that the court being able to order somebody to be present conflicts with the right to trial by jury?
Well, and losing your right then to trial, I mean, the statute says your counsel can appear for you unless the court orders otherwise. And the Constitution says you have a right to a jury trial. Do you think that the statute abrogates your constitutional right?
No, I do not think that being able to order somebody to be present in court violates their right to a jury trial. What violates somebody's right to a jury trial is ordering to be present and conditioning them that fundamental right to trial by jury on their appearance in court, and then finding upon no record that somebody waives that fundamental right absent a knowing, intelligent, voluntary waiver. And I'd like to address the cases that the state cites for their position that waiver by conduct or forfeiture with knowledge is permissible are cases in which the conduct at issue prevented the trial from going forward. That is not the case here. And additionally, those cases, like Illinois versus Allen, for example, the defendant in that case was so disruptive in court, he threatened the judge, he said, this isn't happening, he was talking over witnesses, just being very disruptive. And the court warned him, if you continue this, we're going to remove you from the courtroom. The court removed him. They brought him in one more time. They said, are you willing to comply? Are you willing to behave? He said yes. He continued to be disruptive. They removed him again, and then they brought him back a third time and said, are you going to behave in court? Are we going to be able to proceed with trial? The third time, he did, and he was there for the entire defense case. And so the cases that they cite, these people, the defendants forfeit their rights in order for the jury process to go forward. It's interesting because the cases that they cite the reason the defendants lost those trials, or lost those rights, is so that they could have a jury trial. They didn't lose those rights to prevent a jury trial, to strip them of a jury trial. In Allen, they didn't send the jury home and have a bench trial when he was removed from the court. In Taylor, when he didn't show up after jury selection, they didn't send the jury home and have a bench trial. This is not, as Gilchrist versus O'Keefe stated, then Judge Sotomayor stated that we do not punish people. This doctrine of forfeiture or waiver by conduct is not to punish, but simply because the criminal justice system cannot go forward if these defendants are permitted to act like they are, which is their conduct was literally preventing the trial from going forward. In this case, clearly that is not the case. We had a bench trial in this, or there would have been a bench trial, well, there was a bench trial.
So the distinction there, and this goes back to, I think, my first question to you then, is you would say that as long as that he could still be tried in absentia had he failed to appear for trial, and that would comply. It's just that it would still have to be a jury trial.
Correct.
Okay.
Yes, him being absent, the same as Taylor, the U.S. Supreme Court, they continued on with the jury trial. So all of these cases that they cite, it's contingent upon the trial not being able to go forward. And they are not finding waiver of rights based on a method of deterrence or punishment. The trial court has many ways to deal with a defendant who does not come to court when ordered to do so. They can issue a warrant. That defendant, upon being arrested, ends up sitting in jail, possibly until trial, for an offense that they may not have had to serve a day in jail. Generally, my experience is it's the more unsophisticated defendants who are not coming to court to begin with. And, as far as, even though you're not allowed to punish them, but going down that road of, it's an ineffective punishment anyways. To get their attention, they sit in jail and then they're not going to come back to court. My experience has been when somebody fails to appear in court, they generally don't get out again. They're certainly not OR'd. And in this case, Mr. Salsgiver was arrested on the warrant. He showed up in court on October 15th, and the court OR'd him. The court at that date could have raised his bail. He could have been in custody. He could have had a jury trial. And that would have solved this issue of, well, is he going to come to court? Is he not going to come to court?
So it's just Mr. Salsgiver's bad luck that the court let him go.
Well, under current law, even if he was in custody, they still would have had a bench trial. Yeah. So, but
Counsel, what's the omnibus hearing practice in Kalispell? Around the state, there's a wide variety of practices with those in some districts and courts. The omnibus hearing is nothing more than a conference between counsel and often the law clerk in other districts, courts. It's more akin to a formal court appearance. Some of them are on the record, some of them are not. The statute doesn't provide or specify. So how are these things conducted in Kalispell in municipal court?
So the defendants, as you know, are required to appear, and both the defense attorney and prosecutor are there.
Is the judge there?
The judge is there.
Is it on the record?
It is on the record, and it's been a few years, but I believe we fill out a form. Or maybe, actually, I think the judge asks us the questions on the form, and the judge fills it in. But they are very quick hearings. There's many of them, and they are ordered to appear in Kalispell Municipal Court, and the district court, defendants are not required to appear. I'm not sure about Justice Court. I can't tell you, but yeah. So as far as my sneaking suspicion is that if the court were to rule, well, actually, never mind. I was going to say if the court were to rule in my favor that they probably wouldn't be ordered to be present at the omnibus, but the court would still be able to forfeit their right to a jury trial or waive their right to a jury trial if they failed to appear at the omnibus for all the petty offenses. So I imagine that they will continue to be ordered to appear.
And in your experience in municipal court in Kalispell, what is the role of part or involvement does the defendant actually have? In my experience with these things, these are largely conferences between counsel and the court.
That is the extent that the defendant has. The judge asks them their address, and that's it. Their phone number, just contact information for the court, and they're out of there within, it's a 30-second long court appearance. Their appearance is not necessary. It's strictly legal issues. So they have no input. And that's why in district court, for cases that obviously involve more serious issues, they are not required to be there.
But we have said it's a critical stage in the proceedings, haven't we? In terms of the defendant's right to be present?
They have a right to be present, yes, and they have a right to be present in district court. And I actually prefer them to be present in district court because I've had a couple occasions where they don't come, and then, as we know, to file a motion, it's waived if you don't file it by the omnibus hearing, and then they come to court and they tell you new information about, I want to file this motion, and you had trouble getting a hold of them before because their phone was disconnected, or they are indigent defendants, and so it's like, well, I wish you would have told me that a few weeks ago. So I prefer for them to be there, but it's hard to order them to appear, knowing that if they do fail to appear, you don't want them facing a bail jumping charge either. So, but yes, it is better if they are present.
So, counsel, any comment on the fact that the omnibus form contained, and I know Judge Ortley got off on the ambiguity, but the omnibus order actually didn't require the defendant to appear for the omnibus hearing, but required the defendant to appear for all court appearances.
Yes, I did not raise that.
Okay.
But yes, that could be confusing.
It's that appear for all court appearances that seems to control the whole proceeding, even when a specific order says that the defendant does not have to appear. Is that the course that these proceedings have taken?
Is that the course that...
In other words, is that what the arguments have been, is that is the controlling language that the defendant must attend all court appearances, even though that order specifically said he didn't have to appear for the omnibus?
Yes, I believe the OR form that he signed as well said that he needed to be present at the omnibus, if I recall correctly. And so, going back to the earlier...
Didn't the release order also say, that the penalty would be potentially revoking release as opposed to,
Yes.
It seems there's some ambiguity in there of whether the penalty is really you lose all your constitutional rights here for a jury trial, or do you just face potential revocation of your release?
I thought the language said you shall lose your right to a jury trial. And so shall, to me, means that, yes, you are losing your right to a jury trial. You have no choice. You have no bargaining power. This is a boilerplate form. And as the state said, it's voluntary. It said in exchange, their sentence in their supplemental brief was, in exchange for his release from custody, he voluntarily waived his right to a jury trial. And as we know, I don't know under what circumstances somebody voluntarily waives a constitutional right outside of a plea agreement, which that's inherent in the agreement. You can't get around that dynamic. But any other context, if an officer says, I'll release you from custody if you let me search your car, but if you don't let me search your car, you're going to stay in custody, I don't think a court would ever hold that would be a voluntary consent to search. Similarly, I don't think that a court would ever say, if I'll let you out of custody if you talk to me about this offense, but if you don't, I'm going to keep you in custody. It's simply not voluntary. Again, the voluntariness, as the U.S. Supreme Court has stated repeatedly, it has to be an intentional relinquishment of a constitutional right. It has to be the defendant's goal. It cannot be the state setting hoops to jump through, and he fails to jump through those hoops, and then he's punished for his conduct by waiving a fundamental constitutional right such as a jury trial.
Counsel, do you agree or disagree with Judge Ortley's conclusion that there was ambiguity in these orders?
I do.
And could you articulate that ambiguity?
Well,
I had a hard time.
As he articulated it, the one order said that the OR form said you have to appear at the omnibus, if I remember correctly, and then the omnibus form stated that you may appear by counsel. I might be getting the forms wrong, but one of them said you may appear by counsel. And so there was an ambiguity there. He resolved that ambiguity by stating that he was ordered to be present in person and that there's no evidence that he ever received this form because it was mailed to him, I believe is what he decided.
Was there any finding or consideration on the record by the municipal court judge as to what the factual intent of this defendant was in not appearing or not?
No, there was never any intent there was never any factual finding because it was clear that the court was relying upon the default of appearance provision and not a knowing, intelligent, voluntary waiver standard. I attempted to go there prior to trial. I asked my client on the record, you never intended to waive your right to a jury trial. He said correct, and the court did not follow up with any questions. The court wanted to proceed to trial right then and there.
Is there anything in the record that would be opposite or contradictory to a characterization of this as merely an automatic waiver?
Would there be anything correct about that?
That would contradict that would support some other characterization, such as that, well, for example, that the judge didn't just automatically deem this a waiver, but rather gave some case-specific or fact-specific consideration here?
No, there was no case-specific, fact-specific situation. It did, in a sense, act as an automatic waiver on the condition under Girard that possibly the judge would have entertained some type of, he wasn't able to comply, as the Girard case speaks of. But that does flip the standard on its head. The prosecution has the burden to prove waiver of constitutional rights, and under the standard in Girard, which obviously doesn't involve a Sixth Amendment constitutional right, there is a waiver and then the defendant must come back and offer an explanation as to, or evidence as to why he was not able to comply. One of the examples in Girard was, well, what if the courtroom doors were locked? That would obviously not be an automatic waiver, or he could get his jury trial back after it was, assuming, the judge finding out that the doors were locked. Or in Girard's case, he had some developmental disabilities and some...
Well, the reason I ask is that we have the case law that says that these waivers, if there is a waiver by conduct, it still has to be based on some case-specific or fact-specific consideration. So I'm trying to, and in that same analysis, stated that there can't be an automatic waiver as a matter of law. And how is this anything but an automatic waiver?
Well, it is a forfeiture. Yes, it is. It does act as an automatic waiver. I mean, as the plain language states, upon default of appearance. And as the Girard case says, there is supposed to be an inquiry as to, well, I don't know if it says that there should be an inquiry, but at least the defense has an opportunity to explain why the defendant was not able to comply with the order.
Well, on the default of appearance, that's in the Montana Constitution, which is talking about failing to appear at trial. Montana Constitution doesn't say anything about failing to appear at an omnibus hearing. It doesn't say anything about failing to appear in accordance with a court order at a pretrial proceeding, nor am I aware of any history in that provision. Chief, could he answer that question, please?
Yes.
Yes. May I grab the text?
Sure.
So my recollection was that it says upon default of appearance. It does not specify at trial. So it says upon default of appearance of the defendant, a trial by other than jury may be appropriate. And so I agree with you if it's specified trial, but as this court has previously ruled, it's found default of appearance and waiver of jury trial under the Section 26 absent. Those were pretrial hearings, and so those were not...
Well, because we said it doesn't make it so.
I'm sorry?
Because we said it doesn't make it so.
Well...
that may or may not have been correct. I'm done, thank you.
Mr. Peabody, your time has expired. I'm going to give you 3 minutes for rebuttal.
Okay,
anyway.
thank you. Okay, thank
Talk
you.
quick.
Appreciate it.
We asked a lot of questions, I understand. Mr. Feldheim.
Mr. Chief Justice, may it please the Court. My name is Brad Feldheim. I'm an Assistant Attorney General representing the City of Kalispell. The Montana Constitution provides that a defendant may waive his right to a jury trial upon default of appearance. The Sixth Amendment does not prohibit this. And what we're talking about here is the City Court's application of the default of appearance provision and whether that functional application of that provision violates the Sixth Amendment. Both the U.S. Supreme Court and this Court apply the totality of the circumstances test to the waiver of a fundamental right. Waiver of a Sixth Amendment right must be made voluntarily, knowingly, and intelligently, and the waiver in this case meets that standard. You have to look at the facts of the case because of the totality of the circumstances test. And during the arraignment, Mr. Salsgiver was informed of his rights, including his right to a trial by impartial jury or judge. He signed and acknowledged those rights. The court imposed conditions of release. He was required to maintain contact with his counsel. He was required to personally appear at all proceedings. He was also informed that his failure to appear would result in the waiver of his right to a jury trial. Now, the date of the next hearing, the omnibus hearing, was included in that order, and Mr. Salsgiver failed to appear at that next hearing. And then he failed to appear for 7 months after the arraignment until he was arrested. And so when we're looking at the totality of the circumstances,
But counsel, we don't look at the totality of circumstances. If this were a felony prosecution, there would be no way a waiver of a jury trial would be implied from that situation. And this is the equivalent. This particular offense has to be treated as a high crime.
it is a serious offense, and the Sixth Amendment applies. But the Sixth Amendment standard under federal law is the totality of the circumstances. And the only consideration, and there's many cases that talk about what needs to be considered, and the baseline is it voluntary, knowing, and intelligent? And you got to look at everything at the time of the waiver to make that determination. And so at the time of the omnibus hearing, Mr. Salsgiver had failed to appear. He had been ordered to personally appear, which was authorized by statute. The court has the ability to do that. And he informed Mr. Salsgiver that if he failed to appear, he would waive that right.
So, counsel, if he were charged with a homicide, would you feel that he had waived his jury trial rights under these circumstances?
I think that you can certainly make the argument under the Sixth Amendment, because what the Sixth Amendment requires is simply that, the voluntary, knowing, and intelligent standard.
That would be the standard that would apply to a felony prosecution.
Correct.
Well, wouldn't you want to also know why he didn't appear? I mean, what if he was in the hospital in a coma or something? I mean,
Sure.
We don't have a factual record here, but, you know, under Justice McKinnon's situation, you have a felony homicide and somebody who has some reason they can't appear. I mean, how do we look at the totality of the circumstances here?
Well, we're bound by the record, and nothing was offered. There's no explanation offered. And I think that it's reasonable to assume that some explanation would have been offered if there was some sort of explanation for his absence. Now, there wasn't one. And so we're bound by the record, and the totality of the circumstances that are before us include the signed initial statement of rights, the signed conditions of release, and the order for him to personally appear.
Well, so to the extent that the record is deficient and there was no inquiry made, I mean, even in Girard, even under Article 2, Section 26, we said that there had to be a determination as to the circumstances of each case. Who does the onus fall on there? I mean, when we're sitting here with a record that is incomplete, and this is kind of what I went back to with Mr. Counsel for Mr. Salsgiver, is we don't know. I mean, so isn't there, you're wanting us to infer by virtue of the notice and the pleadings and the fact that he didn't show that it was a knowing, intelligent, and voluntary waiver? I mean, doesn't it require a little bit more of an inquiry than that?
Well, the Sixth Amendment right to a jury trial does not require a colloquy between the court and a defendant prior to waiver. So there isn't necessarily a burden of the court to entertain that. Now, it is a best practice, and federal courts say that consistently. They say, listen, trial courts, you need to do this. You need to make a better record. But at the end of the day, we're talking about whether or not the record as we have it can show and support a voluntary, knowing, and intelligent waiver.
But the record as we have it also has his testimony that he didn't intend to do that.
Which is interesting considering the totality of the circumstances prior to the date of trial. And we can go through that. I mean, at the end of the day, what we're looking at is Mr. Salsgiver was ordered to personally appear. He, in violation of the court order, failed to appear, understanding that he would waive his right to a jury trial when he failed to appear. He failed to communicate with counsel from the outset. OPD had a motion to rescind appointment on April 22nd. That's before the omnibus hearing, and it was because Mr. Salsgiver hadn't provided the financial documentation necessary to confirm appointment. He obviously failed to appear at the omnibus hearing. The defense never offered any explanation for that. He didn't appear in court again until he was arrested 7 months after the arraignment. No explanation was offered for that. The state doesn't have the burden to prove a negative. The state simply looks at the record and has offered that record for that consideration and has argued that was a voluntary, knowing, and intelligent waiver. Now,
Counsel, by the same token, though, how is a void in the record an affirmative showing or a basis for an affirmative finding that there's been an affirmative waiver?
could you ask that again? I'm sorry.
How is a void in the record, which is what you're talking about why he did this and why he didn't get his financial information in for his OPD appointment. So there's a void in the record about what he was doing or not doing. How does that rise to the level of being a basis to make a affirmative conclusion that he intended to waive his jury trial?
Well, I would say this. Ultimately, the court didn't require him to fail to appear. That was his voluntary choice.
But that's the whole point, is the upshot of what you're saying is is that if somebody's been clearly and unequivocally ordered to appear, they don't appear, there's no explanation as to why they did not appear, then we're done. That person, therefore, intended to knowingly, voluntarily, intelligently waive his trial, or her trial, as the case may be. But that precludes a myriad of other circumstances that may or may not bear on that.
And the defense could have raised whatever the issues were that would have undermined this idea that he voluntarily chose not to appear.
Well, when the defense shows up and says, the defendant shows up and says, no, that is not what I intended to do, what do we do with that?
Well, on the date of trial, he was asked whether or not he intended to waive his right to a jury trial, and he said he did not. That's the date of trial. That's November 12th. He still failed to appear.
So what's contrary to that?
His failure to appear at the omnibus hearing.
Isn't that an automatic waiver?
It's not an automatic waiver because he chose to appear. The court didn't force him to not show up at that omnibus hearing. The court required him to and told him that it would be a waiver of his right to a jury trial if he failed to appear. He knew this. He acknowledged that, and he chose to fail to appear. And he not only chose to fail to appear, but he chose to fail to communicate or participate in the process at all. And I think that we have two routes we can go. We can talk about waiver by conduct. And Sixth Amendment rights can be waived by conduct. That's Illinois v. Allen. And we cited the United States v. Goldberg because it talks about the concepts. But Illinois v. Allen is the basis for that. And you can, in this court, in State v. McCarthy talks about this as well, which they cited in Cox. But the idea is that you can waive your Sixth Amendment right to be present at trial by failing to appear. Correct?
Counsel, so I understand what you're saying about waiver by conduct, but in a felony prosecution, trial judges are not waiving jury trials based on the facts of this case. You set the case in for a jury trial, and then if you want a bench trial, then there's a discussion and that waiver takes place. We don't advocate the Section 26 of Montana's Constitution simply because now we're talking about an overlap with the Sixth Amendment. And so the Section 26 says that the right of trial by jury is secured to all and shall remain inviolate, but upon default of appearance or by consent of the parties. So does this provide more protection than the waiver by conduct that you're saying occurred here in a serious crime prosecution?
Does the Montana constitutional provision provide more protection?
Yes.
In a felony case or in this case? Or both?
Well, I'm not distinguishing this case from a felony prosecution. It's just, you've argued that it's a Sixth Amendment jury trial standard, and I'm saying, well, perhaps the Montana Constitution provides a greater protection than just a waiver by conduct.
Well, I think that, and this court has talked about this, but our right to a jury trial in Montana has been interpreted to be broader. But as far as this specific application of the default of appearance provision, I don't know that it provides more protection necessarily than the waiver by conduct theory. I think that it kind of fits, right? And that's the basis for the argument. But the waiver by conduct analysis, you got to understand that you're still talking about, in waiver by conduct, they still consider the voluntary, knowing, and intelligent elements. And it still requires the same thing in a voluntary, knowing, and intelligent waiver as to knowledge and intention. That's the same.
Our Constitution gives the premise upon which a jury trial can be waived, and it says default by appearance, which is defined in statute. And the only place that it is allowed is in misdemeanor offenses, 46-16-120. So I guess to me, I'm wondering how our constitutional provision, Montana's, allows for a default based on conduct.
How does it allow for it?
Yes. How do you waive a jury trial unless you have a consent of the parties, which is the other provision under Section 26, which is what we're doing in felony prosecutions. We were asking for that waiver to be placed on the record. Isn't that consistent with Section 26?
Well, number one, there's other statutes at issue, and ultimately the felony cases they're just distinguishable in Montana because the writing is required. And if you look at State v. Dillon, State v. Rhyme, and talking about what is required in a felony case, that's similar to the federal rule, which requires a writing as well. But the federal cases that talk about this, it's very clear. I mean, there are other ways to get around this, or to go about this. And that's the Singer versus United States Supreme Court case talks about it. And basically what that is at issue there is the Federal Rule of Criminal Procedure 23, which governs waiver of the right to a jury trial in federal court. And it says this is one mechanism, not the only mechanism, and it anticipates states doing something different to set different constraints on the waiver of the right to a jury trial.
We've defined default of appearance in the statute. And we've said that that statute applies to misdemeanors.
And ultimately, Mr. Salsgiver he still waived his right. He was still personally required to appear at all proceedings. And there's a statute that requires that, or that allows a district court, or a city court in this case, to provide that as well. And so if he is personally required, he still must appear. And if he fails to appear, that is not at odds with the Montana Constitution.
But that applies only to the misdemeanor statute.
Sure.
We've defined default by appearance under that statute. It applies to misdemeanor offenses that are punishable by less than 6 months. That's not what we have here. So that statute doesn't apply. He has an inviolate right to a jury trial. Montana's Constitution provides greater protections than the federal Constitution, as I see it when I look at it, because we've just accepted consent and default of appearance under Section 26. Those are the two ways you can waive.
Sure. Which he did. He waived his right to a jury trial upon default of appearance.
So let's talk about that. His lawyer showed up. So in most circumstances, that's not a default of appearance. Business goes on when the lawyer shows up. I can understand if neither the defendant nor counsel showed up, but that's not the facts in this case. So how is that a default of appearance?
Because the district court ordered him to personally appear.
And I'm just asking you about the provisions of the Constitution. He was ordered to appear. That's understood and conceded. The question is his failure to appear a default of appearance as provided in Article 2, Section 26?
I think that it is. It is, because he was required to personally appear. Look at this court's cases interpreting the default of appearance provision. And I think that you can kind of see the court evolution from Cox to Sherlock, but Sherlock kind of refines it, and it's sort of based on Girard. But they're all conditioned upon that statutory requirement to personally appear.
Which applies to misdemeanors.
Which applies to misdemeanors, and this was a misdemeanor.
This was punishable up to a year. It's a high crime.
It's a serious offense under federal law, and it's a misdemeanor under Montana law.
We have a lot going back and forth, don't we?
Counsel, I apologize. I have my needle stuck on this distinction between what's an automatic waiver and what's not. And your position seems to be, if I'm tracking, that this was not an automatic waiver under the facts and circumstances of this case. So if that's the case, and in your view this was not an automatic waiver, what would an automatic waiver look like if this is not it?
Well, the court could potentially, for instance, consider the state cases that were cited by the appellant, and we distinguish those cases. They would say, and there were a variety of different foundations for that, whether it be a local court rule or a statute, and I believe they were in Kansas and Nebraska. They said within 10 days or a number of days you have to opt in to a jury trial. And if you fail to opt in to a jury trial, then you lose your right. Well, that's different than this case, because you're not opting in. You have the right to a jury trial. The only obligation that Mr. Salsgiver had was to personally appear at the hearings, to participate in the process. And you have to acknowledge that the failure to appear, a defendant's failure to appear, creates systemic problems. I mean, even the omnibus hearing itself, and I understand that in practice sometimes they don't seem to matter very much, but read the omnibus order. I mean, it talks about the purpose is to expedite the proceedings. The judge is going to be available for a change of plea hearing. The judge wants to advance the proceedings, and the judge has to balance the rights of the defendant against the court's interest and the city's interest of advancing those proceedings. And so without a defendant appearing, you can't resolve the case. That's an impossibility.
Well, what about counsel for Mr. Salsgiver's point that just told the trial in absentia?
Well, and you can do that because a defendant can waive their Fifth Amendment or Sixth Amendment right to be present at trial by their conduct. And so that's what happens here. And if you start looking at the conduct and the tie between the right to a jury trial and the conduct, think about all the things that happen when a defendant fails to appear. And not just fails to appear at one hearing and then comes back in and says, I'll explain myself. I really want a jury trial. A defendant who fails to appear at the omnibus hearing in violation of the court's order and then doesn't appear again. I mean, Mr. Salsgiver only appeared twice in this case prior to trial, when he was arrested on the underlying offense and then on the bench warrant. And so when the court is trying to advance the proceedings, they have to consider all of these considerations. And as it goes down the line, OPD can't effectively represent him. That's impacting his right to counsel.
The proceedings aren't advancing anyway, because they didn't move forward with the trial in absentia when he didn't appear. So the proceedings aren't advancing whether the jury trial goes away or not. I mean, what would be from an advancing the proceedings standpoint, if that's the objective and if that's what undergirds the whole process there, or the whole argument, is what's the difference from just saying, okay, we're vacating the scheduling order, we're issuing a bench warrant, and then when he's arrested, we'll move on with the trial. The only difference from an advancing the proceedings standpoint is he still has a jury trial when he gets arrested.
I don't think that's necessarily true. I think that the proceedings here advanced. I mean, there was a continuance that was requested. There was actually two, one by the city because of an officer being unavailable, and one by the defendant. There's no explanation as to why those continuances were requested.
No, I understand that, but what I'm saying is from a practical standpoint, what is the difference when you're talking about advancing the proceedings? What would have been the difference here if he still had his jury trial? I mean, the trial wouldn't have been held a day earlier than it was because he failed to appear. They didn't proceed with the trial in absentia. So there is no practical difference other than you conducted voir dire, and you would have had to, the trial would have been slightly longer because you would have conducted voir dire and picked a jury.
Sure. Well, I think that there's a couple things. Number one is there's a difference in the way the court schedules it, and obviously it takes more time, as you referenced there. And it's an onerous thing to do for a defendant who completely disregards the process, and I think that that's part of it. But courts are experienced, and they understand what happens when defendants fail to appear. And so they don't want to try a defendant in absentia. They don't want to do that either, specifically in a jury trial.
No, and what I'm saying is, so let's set that hypothetical aside, the trial in absentia. From a practical standpoint, if the objective here is advancing the proceedings, the jury wasn't called at the omnibus hearing.
Correct.
So from a practical standpoint, either way, when he failed to appear, they vacate everything and they issue a warrant. And so then you just move down the road, he gets picked up again, eventually they have a trial. I mean, it's not, and then when he's there, they either call a jury or they don't in this case because they said he waived it by failing to appear at the omnibus. So neither one really advances the proceedings, neither scenario really advances the proceedings appreciably more than the other.
So would that, in that scenario though, would the right be waived later?
No, I'm saying in one instance where the right is not waived because it's a serious offense and if there's a determination that it wasn't knowing, intelligent, and voluntary, but just you've got two factual scenarios. In one case, the right is not waived. In the other case, the right is waived. But how the nuts and bolts move along, other than when they finally do get to a trial, there's a jury or it's tried by a bench, what's the practical difference? I mean, from a standpoint of if the goal is to advance the proceedings and keep things moving along.
Sure. Well, when a court sets the trial date, number one, bench trials and jury trials are held on different days. Right? They don't do them the same way. So if you have a bench trial scheduled and then you decide, or if you have a jury trial scheduled and then you try to do a bench trial, then you're going to have to change the trial date. So if you set the trial date as a jury trial at the outset, there will be a change in the trial date because it's going to be, if the judge later moves the trial to a bench trial, then it's going to change the trial date.
But you have criminal defendants all the time who may decide the morning of trial. I mean, I've had that experience. The morning of trial, they decide to waive jury. Or certainly the day before within a certain standard. I mean, sometimes judges get cranky about that, but I mean, that happens. So, I mean, you may still, and usually they're not making determinations on waiver until down the road. I mean, they kind of default to the standpoint of, I want to keep that option open, knowing that they can't go back to a jury once they've waived it.
I would say this. In that scenario, if a defendant came in and waived the right to a jury trial day of, and he had a jury trial and he hadn't waived it previously, then at that point, if the court conducts a bench trial on that day, then somebody else who was scheduled for a jury trial is not going to get it that day. And we're talking about implicating other people's rights as well, potentially defendants who are participating in the process, at the expense of Mr. Salsgiver, who has failed to participate in any meaningful way until the day of trial.
But doesn't this happen, I mean, just sort of as a matter of course in felony matters, where you have people who don't appear and, well, we don't waive their jury trial right, and all of the sky is falling type things you've talked about don't really occur in felony district court, and...
Well, I don't think that that's necessarily true either, though. I think that these effects are real. It's just how does the court deal with them? And the city court in this case, they're simply applying Montana Constitution and the default of appearance provision to the right to a jury trial in this case. So that's what the city court is doing. The question becomes whether or not that violated the Sixth Amendment. And so that's the argument, right? Whether or not the Sixth Amendment and the Supreme Court's cases interpreting the Sixth Amendment allow this kind of a default of appearance application.
Counsel, you have cited federal precedent, and my question is, do you have any precedent from this court, and I don't think there is, interpreting default of appearance under Montana's Constitution? Other than Cox, Girard, Trier,
no.
We've never interpreted that.
That's correct.
Okay.
As far as I know.
So, Mr. Zeldin, in State v. Walker, we did rely on federal authority in saying that for waiver of jury trial, the Constitution doesn't require a specific colloquy for advisement of rights. And that was in the context of a guilty plea waiving the right to a jury trial, where we held that the advisement that you have the right was enough. So how does that translate to a waiver by conduct theory in this situation?
Well, I think that ultimately what you're talking about is this court acknowledging this idea that all the nuances don't need to be explained to support a waiver. And it mostly goes to knowingly and intelligently in my interpretation. And so when you start talking about having a colloquy, the defendant needs to know what the right is, which happened here.
And because you have talked about it being knowing and intelligently, to me, and maybe I'm missing something in your argument, but you're not really strictly talking about default of appearance being the reason. Because by saying it was knowing and intelligent, you're relying on the warning, which is similar to the warnings one gets in a colloquy. So I think your argument is going beyond just the default of appearance clause in this instance, but I might be getting confused.
No, you're not confused, and that is the argument. If I'm not conveying it very well, then that's my fault. But I think what you need to consider is the totality of the circumstances and whether or not these elements are met. And so, was there an official colloquy? No. But these are the things that he knew. These are the things that the court explained to him and he acknowledged. And those are all facts that can be considered as part of that analysis. And you can't simply ignore the facts. And I think that that's maybe what you're saying, is that there are facts on this record that support the finding of a voluntary, knowing, and intelligent waiver.
Well, except for you've been talking about knowing and intelligent. I mean, and the voluntariness is what he voluntarily did was not show up for court. I mean, at least presumably. I mean, when we look at when a waiver of any constitutional right is knowing, intelligent, and voluntary, oftentimes the analysis is somebody comes in, they waive, and then we look at, well, did they know when they made that voluntary waiver, did they know what they were doing, and was it an intelligent and knowing waiver? I mean, in this case, it almost seems like you're kind of saying the voluntariness is just subsumed by knowing and intelligent. He knew that he knew he was supposed to be there. May or may not be a relatively intelligent guy, and then he didn't show up, so we're going to just assume that that was a voluntary waiver because of his failure to appear.
I don't think that there's an assumption here. I think that the fact is that he understood that he needed to personally appear at all proceedings. He understood that that would be a waiver of his right to a jury trial if he failed to appear. And the only voluntary action at that time that we can even talk about is whether or not he chose to there's no voluntary act other than him signing the form, right? And he signs it. He signs the form, and then when he fails to appear, that's the actual voluntary act. And that's where this waiver by conduct theory comes in.
Counsel, what about the situation where you have a defense strategy where the counsel does not want the defendant to be present during the trial for purposes of identification or for some other reason? And that defendant, or the implication of what you're saying is that the defendant has no jury trial right in that situation. He doesn't have a right, or she doesn't have a right to be tried by a jury because their defense strategy would be, I don't want to be present for purposes of identification or something like that. So,
well, I think that ultimately there might be some defense strategy that could be discussed, but there's time to do that. And if you have a defendant who's participating and have an ability as a defense counsel to make a strategy and come up with a strategy with your client, then perhaps that's something you could go to the court with. But those aren't the facts of this case. We have a defendant who failed to appear and failed to participate in the process, and that's the point. Look back to Cox. Look back to this court's interpretation of the default of appearance provision. It's unqualified. It's unambiguous. There's a reason for it. It's because of the systemic problems that are created.
Because it's easier for the courts to handle misdemeanor case processing.
It certainly is easier, there's no doubt. But it also affects the process, and we can't forget that it does, in fact, affect that process. And again, implicates other people's rights, implicates his counsel's ability to effectively represent him. Right? So, I mean, there is a systemic problem that is created by defendants like Mr. Salsgiver, and city courts understand that, and they deal with it all the time.
So does the legislature and this court as well,
correct,
based on Cox and those prior decisions. But
Counsel, on intermediate appeal, Judge Ortley found that these orders taken together were ambiguous, and then he proceeded to resolve the ambiguity. Do you agree with him or disagree that the orders were ambiguous as a threshold matter?
Yes, they were ambiguous. Yes. They were inconsistent.
So if they were, how do we expect a non-lawyer citizen to engage in resolution of ambiguities in court orders?
Well, I think that the problem with this analysis in this case is that there's nothing in the record that shows that he relied on those orders, and the district court talks about that. If Mr. Salsgiver was in fact confused as to whether or not he was personally required to personally appear, then that would create some sort of an issue, and it certainly is a potential based upon the language in the omnibus order.
Well, so counsel, but I mean, isn't that somewhat inconsistent then when you say that we should rely on those orders to establish that he made a knowing, intelligent, voluntary waiver, but we shouldn't rely on those orders or the ambiguity in those orders to controvert that it was a knowing, intelligent, and voluntary waiver?
May I answer?
Yes.
It's not inconsistent because we're not relying on the omnibus orders at all, because nothing in the record shows that he got it. And ultimately, you have the notice of omnibus that was mailed to his counsel. But remember that there was a motion to rescind appointment of counsel because they weren't talking to defendant. And so the conditions of release is where the order came from. And it was unequivocal. Your personal presence is required. Thank you.
Thank you, Mr. Feldheim. Quick 3 minutes.
The state is arguing that because there's no record in this case that benefits them. However, that is in clear contradiction to every Sixth Amendment case and Boykin versus Alabama that says that a waiver of a federal constitutional right is governed under federal standards, and those standards are that you cannot presume waiver of a constitutional right from a silent record. You cannot presume, we indulge in every reasonable presumption against waivers of constitutional rights. And as U.S. versus Robinson said, we cannot find a waiver based on mere speculation and conjecture. And that is exactly what they are arguing in this case. Saying, we don't know what happened, we don't know what happened. Well, the defendant could have done this, the defendant could have done that. That's not the standard here. We do not presume waivers of constitutional rights.
But we have said that there is no specific colloquy required to have the waiver, and I think the state's argument is he had knowledge of the warning and disregarded it, and that was enough. How do you distinguish between the federal law and no specific colloquy and the argument you're making, which is that this is a silent record? It's kind of in between those two things.
So they make the argument that there's no requirement for a written waiver, there's no requirement for a colloquy, and what they're saying is that essentially is that there's no per se rule that you need, or per se threshold that you need to meet to find a knowing, intelligent, voluntary waiver. That's very different from not requiring anything, which is what they're asking for. They're asking for, you know, he said that the judge informed him of his rights to jury trial. What the documents state is that he said failure to appear will result in your jury trial being waived. It didn't say what a jury trial consisted of, or even that if you fail to appear, you're going to have a bench trial instead of just deeming you guilty. As Boykin said, those are, you need a valid waiver, knowing, intelligent, voluntary, to waive not just your right to plead not guilty, but the rights inherent in a plea of guilty, which one of them is a right to trial by jury. It is also a little alarming that the Sixth Amendment has been around for over 200 years, and they cannot cite a single case where somebody has not been convicted who waives a fundamental right as trial by jury based on failure to appear. They have to analogize it with these loss of counsel cases that do, in fact, present a trial from going forward, whereas this does not. Illinois, the cases they actually cite demonstrate that you don't need the defendant there to have a jury trial. So their own cases contradict their own opinion. And I see I'm out of time, and I appreciate the court hearing this case. Thank you.
This concludes the argument in this case. Thank you to both counsel. Thank you also to those of you who are here. We appreciate you taking the time this morning to participate in this important process in terms of our criminal justice system. Thank you very much. Thanks again to the University of Montana Law School. We will take this matter under advisement and issue an opinion in due course.